You revoke his bail. Even if you take Mr. Claus's, representations to the court.
Hang on, I let you talk for. All right, calling page, let's go back on record. Calling page 6, Lamonte Butler, C371483-8. All right, Mr. Butler is present in custody with Mr. Claus. We have Mr. Portz and Mr. Brooks for the state. We're on for motion to reinstate bail. I did review the your initial motion, state's opposition, and then the reply that was filed at 11 o'clock last night. Okay.
Busy as a one-legged man in a butt-kicking contest, Your Honor, but hopefully you found something of interest there towards the end of that motion.
All right, state.
Judge, unless you have any questions, I'll sit down pleadings.
Did you want to respond regarding the reply?
I didn't see anything that was anything new in there. So the state's position remains the same, that they've raised no new facts or circumstances. So the motion should be dismissed. And even if we addressed it on the merits, everything we put in our pleadings established very clearly the court had every legal grounds to do what it did, having deferred its prior ruling on the proof evident presumption grade.
What did you specifically want me to argue? Because now I'm wondering, because I read it and I wasn't sure what you're referring to, Mr. Claus.
Okay, so a couple of things, Your Honor. I had to go through and get all the transcripts here because what's clear is the state made multiple attempts to revoke bail. And while they couch their final motion that's filed in March as a clarification, it's not a clarification, Your Honor. It's a revisiting. In fact, it's so little of a clarification that the vast majority of that motion consists of their Exhibit A, which is an attachment of their November motion filed to revoke his bail. The basis for the November motion is just a little over 1 page of legal argument, which starts with proof evident presumption grade and ends with the argument proof evident presumption grade. The final fact that they add in, Your Honor, is the autopsy report. So, Your Honor, while the record is ambiguous, I will grant, as to whether or not you find proof evident presumption grade, at the end of the day, the record from the November motion is 100% clear that you deny the motion to revoke bail. And it's their motion. It is based solely on proof evident presumption grade. As I said, it's in line 1 of their motion. It's the last thing that they say in their motion. And of all the case law that they cite to, it's all proof evident presumption grade. There's no other basis, no other changed circumstances, no other good cause that's proffered by the state. Now they come back months later and they say, we'd like you to clarify your position because we don't think you made a ruling on proof evident presumption grade. But one thing that they do in both of these motions, which, Your Honor, maybe I'm a simpleton, but this is something that I've been arguing about for a while. And I thought this would catch the court's eye because it's an argument that I've had in the justice of the peace level and the district court level, all the judges who are hearing this. The state's position is that NRS 178.484 subsection 4, the proof evident presumption grade statute, says that the court may not grant bail when the proof is evident of the presumption grade. That is their status. It's wrong. It's been wrong for 20 years. And it took me many years to find the case law, Your Honor, in front of you. That's why I said I thought you'd find that interesting. In the Bergman case in 2004, the Nevada Supreme Court was asked by the Washoe County District Attorney's Office, so not this district attorney's office, but the Washoe County District Attorney's Office, to pass on the proposition that once someone is found guilty of first-degree murder, can they be granted bail pending an appeal? The Bergman case says the state is taking this position that 178.484 subsection 4 says that when we find proof evident presumption grade, the court can't set bail, and therefore giving bail after they've actually been convicted means that you actually have a lesser standard for bail being granted after you're convicted than you do before. And you actually get bail after you're convicted rather than when the proof is evident in the presumption grade. And the court says in 2004, it's wrong. You read both of these things harmoniously, both the statute giving bail after a conviction and 178.484, and that the court is not categorically precluded from giving bail after proof evident presumption grade is found. Now, you continued this last time because I needed the minutes from those last 2 hearings to find out exactly what happened there, or the transcript. And what it looks like, Your Honor, is that exactly what the state said was what the court's finding was. The court says, I don't care about how well he's been performing. I don't care about any of the statutory factors before this point, which, by the way, is the opposite of what the Burton case says the court has to consider. And the court says, once I found proof evident presumption great, the bond should have never been granted. The bond is voided. And that's not accurate. It's not an accurate statement of the case law. Now, perhaps I missed that, and I think perhaps the state missed that. But Your Honor, for 20 years, this case law has been hanging out there in the ether, and I don't know people who have actually looked at it. I've been searching for it for a long time. But the Supreme Court said in 2004, very clearly, as part of their holding, that 178.484 does not preclude the granting of bail. It doesn't. The court still has the discretion to grant bail. So to the extent that the court actually said on the record, because I'm finding proof evident presumption great, the bond is voided, can't be granted, that's an error. It's a legal error. It's a legal error, Your Honor, that the state has perpetuated, not once, but twice. In their motion in November, they said, if proof evident presumption great is found, you may not grant bail, underlining the not, bolding it. In their motion for clarification, which attached their November motion. In March, they said again, 178.484 subsection 4 says the court may not grant bail upon a finding of proof evident presumption great. And Your Honor, it's wrong. The Washoe County District Attorney's Office took that same position when they took an appeal up to the Supreme Court. I will grant, Your Honor, I don't think that the state has been willfully, deliberately misleading the court. But Your Honor, the case law in Bergna is 100% black letter clear. It requires no extrapolation, no elucidation. They take both of those propositions that when somebody's convicted of first-degree murder and when someone is found that when there is proof evident presumption great, that bail must be denied, and they say flatly, we disagree. And they give a whole series for why they get there, Your Honor. But the end analysis is the state is absolutely wrong. Absolutely 100% wrong. What led me to this was, frankly, Your Honor, I was talking to my brother Conrad when he was at the district attorney's office. He conveyed a story involving Judge Sobel, where Judge Sobel had someone who pled guilty to first-degree murder, 2 counts, pled guilty to and stipulated to a sentence of life without the possibility of parole. And yet this person remained out on bail. And what Conrad said is that's not something that could actually happen. And if the state's correct, that once proof evident presumption great is found, the person has to be denied bail. And the Supreme Court, in that case, when Judge Sobel apparently came to that conclusion himself a week after entering the plea for this individual, and I should probably get to that case, Your Honor, I apologize. It's not part of my brief because it's what got me thinking in that direction, but it's not actually it doesn't actually make the finding, because that's based on the plea agreement that was entered. But that's Crawford v. State, Your Honor, 117 Nevada 718. But Judge Sobel did the exact same thing a week later, apparently came to his own conclusion a week later, saying, well, he's pled to first degree, he's being sentenced to life without the possibility of parole, 2 counts, he has to be remanded into bail. And the Supreme Court said no, it was part of the negotiations, it was part of his expectation that he was going to remain out of custody until sentencing came about. He was going to spend the holidays with his family. And despite the fact that this person had pled guilty, had stipulated to a sentence of absolute prison without the possibility of parole, the Supreme Court said it was error to remand this person into custody a week later. Now, the Sobel case, the Crawford case, is not 100% on point. It got me thinking. But the Bergman case is 100% on point. To the extent the state convinced you that you cannot grant bail for someone where proof is evident or the presumption great found, they're wrong. Which leads us to an interesting chicken or egg argument, Your Honor. And that's where this gets me flipped around. Your Honor, the state made the proof evident presumption great argument in November. The court said in those November hearings, I knew that the victims were in a precarious position at the time that I set bail. I knew all of the facts associated with this. The state made as part of their arguments the autopsy report that the court ultimately looked at later on in March and April to determine this was new evidence. It wasn't. While the state might not have given it to the court, while the state might not have met their burden, there's two problems with that. The proof evident presumption great standard is the state's burden. It's not the defendant's burden. Case law is clear on that. They have the evidence. They are the ones who brought the people in front of the grand jury. The defendant shouldn't be forced to search around in the mud to find something to rebut that. But
when what they give me shows that a coroner is saying this is first degree murder, or this is, sorry, a homicide. And it was directly related to the home invasion that occurred months earlier, despite the intervening potential factors of him checking himself out of the hospital. That's all I have in front of me. I don't have anything to show another side. And so I'd given Mr. Troiano, and ultimately the defense is still working on getting some information regarding that. But like, that's all I have in front of me is pretty black letter that the coroner, a medical professional, believes this when I'm not a medical professional.
Well, if I may be so bold, Your Honor, you had that information in November, and it wasn't a surprise to the court. The court was aware of it, was aware of the precarious circumstances.
An autopsy in November?
Yes, in the November motion that the state filed, Your Honor, there is a whole paragraph which is included in my motion that is devoted to the autopsy report showing that as a result of this crime, the victim died. This was included in the November filing by the state. And like I said, the November filing.
Autopsy attached.
I don't know if the autopsy was attached, Your Honor. I don't know if it wasn't attached to the pleading itself. It might have been submitted some other way, but Your Honor, it was in the pleading. And I even quote to it, Your Honor, in the reply from the November filing by the state. They go forward and they say, I think I have to pull that up directly. Yeah, the state talked, this is in their November bail motion to revoke his bail. On September 11th, 2023, after suffering for 8 months from the injuries sustained in the attack by defendants Queen, Washington, Lee, Kenneth, and Butler, victim Hung Shu Lee succumbed to his injuries and died. On September 20th, 2023, an autopsy was conducted on Mr. Liu. On October 4th, 2023, following a review of Mr. Liu's medical records and history, medical examiner Stacy Simmons, the same autopsy report that the court relied on 5 months later, issued an autopsy report concluding the cause of death to be complications from multiple blunt force injuries and manner of death to be homicide. So, Your Honor, this was in their motion. And what's more than that, Your Honor, you took it under consideration. When we look at the hearing associated with that November filing, you don't gloss over that. You say specifically in the hearing, I knew about the precarious medical situation of the victims here. I knew about the violence of the offense. And yet you say the bail should remain where it's at. And what's more than that, Your Honor, there's a colloquy after that with the defendant about, what should happen to the bail in January, even after November. In January, there's a colloquy with the defendant 30 days before he posts bail, where the court is talking with him and says, no, you can post the $500,000 bail. You're on PCU as part of that requirement. You can absolutely leave in accordance to those items. So, and the state reiterates their position in January. Again, our position is bail should be revoked because of proof evident presumption great. He committed murder. That's what we'd ask you to do. But Your Honor, if this being Mr. Butler, if Mr. Butler wants to readdress bail, it has to be done in writing. Then 30 days later, Mr. Butler posts bail and the state comes back to you and says, motion for clarification. And Your Honor, it's not a motion for clarification. It's a motion for reconsideration. While I will grant, Your Honor, that in November, the court did not make an explicit finding on the record of the proof evident presumption great. Your Honor, there was nothing else in the state's filing. There was no other legal basis that was offered. The legal basis offered by the state was less than just over 1 page long if you include the conclusion. And it started with proof evident presumption great, analyzed proof evident presumption great, and ended with proof evident presumption great. And right before it was the factual recitation of the autopsy report. And in response to that, Your Honor, while you did not make an explicit ruling in November on proof evident presumption great, what you did explicitly say is I knew about the precarious medical condition of the victims. It's not a surprise to me that they died here. The bail doesn't have to be revoked at this point.
So to be clear, your argument is even if I did find, ultimately I didn't find proof evident, I didn't make a determination on proof evident presumption grade at that first hearing. Ultimately, I do find it. Your argument is that he should still be entitled to bail.
Yes, Your Honor. And the reason for that is, Your Honor, twofold. This is not the first time the state's moved to deny him bail. As I go through in the factual recitation, this case has a tortured history, starting in Henderson, starting in Justice Court, ultimately be indicted, not once, not twice, not 3 times, but 4 times now. And each time the state comes back and says, deny him bail. And Your Honor, they did not agree with your bail setting when you set it for $500,000. They asked for more. They did not agree with him being able to post the $500,000. They asked for him to be revoked. And Your Honor, there was a disagreement in the Henderson case, which is another thing that took me some time to figure out because it was a different attorney. There was a disagreement in the minutes as to whether or not he posted his $250,000 bail, $250,000, but it looks like it was only $24,000 bail that was posted, whether that was pure cash or whether or not that was bail, Your Honor. The Henderson minutes did not give me access to that. But Your Honor, he posted bail in the Henderson case. Ultimately, that bail was lost to him as well because of the state's manner in how they indicted this case, how they charged it. And they didn't just charge it once in Henderson or once in Justice Court. They charged it multiple times and robbed him of one bail. Now, Your Honor, here they are robbing him of another bail. And there's really no other way to describe it. First of all,
so it would go back to the person who posted it.
Pardon?
It was voided, so it would go back to the person who posted it.
Well, no, in your case, but for the Henderson case, Your Honor, it wasn't voided. It was exonerated. It was lost.
So they can't be described the same way is what I'm saying. There's a difference in how they were treated. Ultimately, that other one probably should have, that would have been up to the justice of the peace. But in my decision, I didn't think it was fair that they would hold on to, that the bail bondsman would get to hold on to it. And so I treated it differently. That was one of the reasons ultimately that I did it void which we're holding on to at your request.
But the problem is here, Your Honor, this is not the first attempt by the state to revoke his bail or the second attempt to revoke his bail, or even the third. There's been a Valdez-Jimenez. There's been oral motions to address the bail, to revoke the bail. The state has filed multiple written motions, and their final attempt is couched as a clarification. Your Honor, the NRCRPs don't even have a section for clarification. And the state didn't offer you any new facts at that hearing than what they'd already given you in November. Now, they might have done a better job of giving you the facts, but Your Honor, there were no new facts that were proffered by the state there. The only new fact that was proffered, which the court blatantly denied, was this idea that somehow my client had to have been lying to the court about his ability to post bail when he told on the financial affidavit what he thought his family might be able to post. And the court clearly said that doesn't even fly here. First of all, the state doesn't have anything other than speculation that the defendant was lying about that. Second of all, Your Honor, we have his family here in the court. He didn't post that bail, his family did. And the position being, whether it's his family mortgaging their house or setting up a GoFundMe page, these funds didn't come from him. Manifestly, he was in custody when all of this happened. What this was is his family hitting a target that the court set, and not only set, but led him to believe in January of this year that had he posted that amount of posted that bail, he'd be out. Your Honor, so his family came together, they scraped together, they mortgaged their house in order to get him a bail. And then when he gets the bail, Your Honor, he doesn't come back to court when the state tries to throw him in custody one time. He doesn't evade. He comes back twice, knowing that the state is trying to revoke him and throw him in custody. Your Honor, that is no better showing of his ability to come back to court and not engage in further criminal behavior. As the state said in their motion, at some point, it's going to sink in to the defendant that he's going to spend the rest of his life in prison. And that's what we're seeking, and that's what we're going to get. And he's going to come to that conclusion at some point, either after trial or sometime before trial. Your Honor, bail is never meant to be putative. And even if proof is evident, presumption is great, he's still entitled to the bail. And there still has to be some methodology of implementing the bail. The Bergner case says that. It's not that bail factors go away, which is respectfully what you said, is that the other bail factors go away. It doesn't matter how well he's performed, doesn't matter about the analysis that you'd performed previously. Once proof is evident, presumption is great, you felt that the bail had to be voided, that he wasn't entitled to a bail any longer. That's simply not accurate. Now, I'll grant you, Your Honor, state didn't give you any of this case law. I will grant that they made a mistake. It comes in part from how they talk about NRS 178.484, and it's one of the disagreements that I've had for years.
I'll let them argue what their position is. But ultimately, a lot of this procedural history, I mean, it lives through. So what's your final argument?
My final argument, Your Honor, is that you addressed this, Your Honor, albeit not explicitly, in November. When the state came back in March, filing their motion, they couched it as a clarification because they couldn't say what it was. It was a reconsideration of your prior ruling. You had made a determination, Your Honor, that their motion to revoke bail was to be denied. The sole legal basis proffered in November was proof evident, presumption great. There is no other legal standard discussed in the entirety of their legal analysis. And right before that, Your Honor, they go through exactly the factors that the court later considered in March and April, for their putative motion for clarification, namely the autopsy. And while they might have done a better job of giving it to the court, and they might have done a better job of making their arguments, Your Honor, that's not the standard. The standard isn't we let the state keep on coming back, it bites at the apple until they finally get it right. The standard is when they come to you the first time, they make their best argument. And if they can't, then they have to show good cause as to why they did not make that show the first time. What has changed? And there is no good cause here. What it simply is, Your Honor, is he posted bail. He posted bail after the court told him that he could post bail in January. After the argument had been had on the proof evident presumption great motion by the state, after the evidence of the autopsy had been proffered, and granted, Your Honor, well, I will admit that all the parties were probably surprised by that outcome. There is no case law that I can find that even suggests that when the court has made a detention order and set bail at a certain amount, that the fact that the defendant actually posts bail constitutes good cause to raise it. In fact, the exact opposite.
That's not what I'm saying. Ultimately, I determined that I had never determined proof evident presumption great. When I looked at everything, I couldn't figure out a way not to determine that with the evidence that was before me. And so that's ultimately what I determined. The proof was evident, the presumption was great when I sat down and looked at it. I didn't know how to get around that finding in any way, even though all the things that you're saying, I was very much aware of, and I knew that he had come to court, and I knew that his family had worked very hard to get that bail, and I understand those things. But at the end of the day, I don't know how you get around proof evident presumption great in this case.
Because, Your Honor, proof evident presumption great doesn't actually alter the standard. While it changes the constitutional imperative of both the Nevada Constitution, the federal Constitution, and Valdez-Jimenez saying that you must give a bail. At the end of the day here, the state's position isn't that you gave him a bail that you thought was obtainable. You did a detention order. The difference is
What does
that
a detention order mean if people can post it? Like, I don't really know what Valdez-Jimenez even intends for the purpose of cash bail to be.
well, okay, so that's a longer argument. As I read Valdez-Jimenez, Your Honor, Valdez-Jimenez creates three levels of presumption. The first one is a presumption for non-monetary bail, and to the extent that non-monetary bail cannot suffice to meet the court's concerns for either recidivism or coming back to court, then it provides for cash bail or some
But what does
combination
cash
of those
bail
two.
do if somebody can post it?
Well, it gets a bail bondsman, Your Honor, who independently monitors the individual, and then if the person leaves their contractual the bail bondsman's put independent contractual circumscriptions on
But
the
what's the
individual.
purpose of it? Because we're saying that cash bail, whatever.
Well, the purpose
I
is
don't
to
know
have
why I'm
another
going
set of
down this
eyes. The purpose is to have another set of eyes. And Your Honor, here, cash bail, the purpose is to get his family invested so that if the defendant absconds, he's not just absconding and the bail bondsman's on the issue, but his family's house is on the line. And that, Your Honor, is how cash bail worked here. While I'm, Your Honor, I tend to believe that cash is a great equalizer, and that I prefer cash bail because it doesn't care what color or socioeconomic status you come from. When you come with cash bail, you got cash bail. In this case, it
Well, your
works.
socioeconomic status allows you to get cash.
Well,
Cash
here-
is literally what you just said.
But here it didn't for my client. What happened is his family was able to come together and overcome whatever burdens they needed to post that cash bail. It didn't matter the fact that my client was found to be indigent and was appointed counsel, which the state took issue with. That is not the question. The question is whether or not the family members and the client can post the bail. And Your Honor, cash bail provides that assurance. When my client's family members, and Your Honor, I would make an offer of proof to the court, though I don't have the contract from the bail bondsman, that my client's grandmother actually put up a mortgage on her house to secure the bond, then that exactly gives the court the sort of assurance that it could never get themselves. It gets other people for which he is related being directly on the hook if he violates his conditions of bail, if he flees the jurisdiction. And while I will grant to the court that the money itself isn't what the court wants, what it wants is assurance that he's going to show up. And that's what it got.
Okay. So to summarize, I've found proof evident presumption great, but you still think that ultimately that I should have kept the same bail?
Yes, Your Honor. Because the proof evident presumption great existed months before you made the determination, and it was predicated on a November motion filed by the state, which offered you nothing but proof evident presumption great. And you indicated
So I should have
that
found it earlier?
I think, Your Honor, there's an argument, and this is why I had to get all the transcripts. I actually thought that you'd come to the proof evident presumption great hearing as part of the finding in November. And while I have to grant to the state that you did not explicitly say, I'm finding proof evident presumption great, what you found is that this has worked as a detention order. He's staying in custody. I am not going to raise the bail just because of things happening that I reasonably expected to happen when I set bail initially.
So you needed clarification on the wording? Also,
Say again?
you said you had some confusion with the wording, you needed some clarification.
I'm not sure what the state is talking about, but in terms of the clarification of the wording, Your Honor, and what I'd love is to have the state offer some legal authority for clarification. By the way, Your Honor, there isn't any. There is a motion, Your Honor, for reconsideration, and that's clearly what the state sought. It offered no new facts. You knew about these facts. You suspected that these facts were going to occur, and when the state gave you proof that the autopsy result indicated that there was a murder charge here, you said none of that surprised you.
Okay.
But you're still going to deny their request to revoke bail outright. And as I said, Your Honor, chicken or egg argument. You can say, Your Honor, that at one point Valdez Jimenez compelled you to set a bail, but you didn't set a bail that you thought was attainable. You set a bail that was so high it functioned as a detention order.
Because there was no first degree murder, I didn't have that option.
Well, but Your Honor, when you came back and there was a first degree murder in November, you explicitly stated on the record, I saw this coming. I was made well aware of the health problems of the victims. This is not a surprise to me. And while you didn't say, I find proof evident presumption great, you did say, none of this is a surprise to me. And the state's motion was nothing but proof evident presumption great and the autopsy report. Those were the only new facts that they gave to you that didn't pre-exist their motion. And then, Your Honor, in January, they come back, new counsel, and you tell the defendant explicitly, after the proof evident presumption great argument, after the motion to revoke bail, go ahead, post your bail, and you'll be on PCU. So, Your Honor, bail has to, if it's going to be increased, it has to be based on good cause. And good cause isn't that the state makes a better argument. There is no case law that I'm aware of that says good cause is the state makes a better argument. The case law that I found on good cause is where someone is convicted and ultimately the judge remands them. But even then, in NRS 178.499, the Supreme Court doesn't directly address the issue and say it's moot because he's already been sentenced and is in custody. So denying him and reminding him into bail for good cause, they never get into what that good cause is. We ultimately know that you can't change a bail setting once it is set unless you've got good cause. And while the state did an admirable job of trying to bootstrap into good cause, the simple fact of the matter is they made all of these arguments 5 months ahead of time.
Okay. State.
So I feel like 98% of what he just said is just useless fodder that has absolutely nothing to do with the issues that we're here on. He was found, he was indicted on first-degree murder, with use of a deadly weapon. The court deferred its finding on proof evident presumption rate because the court believed, based on his representations to the court, that the bail you set was unattainable. That was the sole reason the court deferred its finding. They didn't seek clarification or reconsideration. We asked the court, can you please issue your finding now on proof evident presumption rate? Your Honor reviewed it, you found proof evident presumption rate, you revoked his bail, which the statute and the Constitution clearly permit. So we have heard absolutely nothing here that changes any of those very simple facts, the procedural history of this case, that once a murder came through, the court deferred its ruling on proof evident presumption rate and then issued a ruling on proof evident presumption rate and revoked his bail. We don't need to hear about the reason and the purpose for bail. We don't need to hear about the history of all the different crimes he committed. The bottom line is this: he murdered an old man in his home in the most violent and terrifying way possible. And the proof of that murder, of him committing that crime, is evident, and the presumption that he will be convicted of first-degree murder is great. And yes, we will be seeking to ensure that he dies in the Nevada State Department of Corrections. That's our intent in this case. But at the end of the day, what the law says is once you find proof evident presumption rate, you revoke his bail. Even if you take Mr. Claus's, representations to the court.
Hang on, I let you talk for 20 minutes. I'm gonna give them at least.
It says
5
unless proof evident presumption rate, then he's not entitled to bail. So even if you take it as the court has discretion, then you have the discretion to revoke his bail, which is what this court did. You've held him without bail pursuant to the statutes and the constitutions in this case. The state's not seeking a reconsideration. And even if we did, and he's hung up on us presenting new facts, we advised the court of multiple new facts, including the fact that he misrepresented to you an ability to make bail. Because you thought you set bail in an amount that he could not attain. You doubled what he said he can make. And you reiterated that point when you deferred your ruling on proof evident presumption rate. He's not making this. I'm going to defer my ruling on this. And so that was one issue that we pointed out. We also highlighted the fact that when you're on a set bail, you weren't aware of the fact that him and his co-defendants were planning new and additional home invasions that we have since had granted in a bad act hearing that will be presented to the jury in this case. You weren't aware of a number of other things that we cited in our motion. Those were all new pieces of information that we cited because our motion was two-part. It was one, reconsider his bail, or two, issue your finding now on proof evident presumption rate and revoke his bail entirely. So it was a two-part motion. And then one of them we highlighted all the new things that the court was unaware of, and then the other we highlighted you deferred your ruling on proof evident presumption rate. You make that finding, we're asking you to revoke his bail, which is exactly what this court did. What I'm still waiting to hear, though, regarding new facts, is what has changed since the court made that order that permits the defense to bring up this motion, which is in fact a motion for reconsideration. Nothing has changed since Your Honor issued that order. So if he wants to sit here and spend 30 minutes touting on and on about the fact that we need to present, the law requires that you present new facts and circumstances to raise a motion to reconsider, then please, Mr. Claus, tell us what has changed since then. But even if you do consider this on the merits, which you don't have to, even if because you can dismiss it pursuant to the defense argument, but even if you consider it on the merits, Your Honor is absolutely within its discretion to hold the defendant without bail because he murdered an elderly man in his home and because the proof of that crime is evident and the presumption of his guilt is great.
Mr. Claus, you had a comment regarding Mr. Portz's representation.
It's almost irresistible for the state. And I gave them the credit of not knowing this case law, Your Honor, because I didn't know it. I'd been looking for it. I'm not sure the court was aware of it. But their representation, there are multiple representations. Their representation here to the court that when you make a finding of proof evident presumption rate, the court cannot give bail is flat out wrong. It's been flat out wrong for 20 years. It's black letter law that is not only cited to by the Nevada Supreme Court, but there is not a single opinion distinguishing it. It's still good law to this day. The difference is, Your Honor, they've gotten so used to telling this to the judges and having their way that even here it's irresistible for them to tell you, you can't give him bail. And no, Your Honor, that's flat out black letter wrong. And I don't know how it eluded them for the last 20 years that the Supreme Court came to this conclusion, because, Your Honor, I get murder cases every now and again. I might have a number of them going right now, but it's not what I do all day, every day. The state doesn't have that out. So yes, if they want to apply the same burden to me, and this is not going to degenerate down to a Monty Python argument factory skit, where they say, we got our reconsideration first, you don't get your reconsideration. Here's the reconsideration. They misrepresented the law to you, and they did it again this morning. The law is wrong in their brief, not once, but twice, and here when they're arguing you today. When you find proof evident presumption great, the Nevada Supreme Court has been clear for 20 years. You can still set bail. How that affects, Your Honor, the constitutional imperatives is something that's yet to be explored, because for the last 5 years, 10 years, 15 years, the state has been coming before the court and saying exactly what they said in writing in this motion. You may not set bail. So it's never been explored. Here's what we do know. The Nevada Supreme Court, when setting bail for someone who was convicted of first-degree murder and requesting bail pending their appeal, said the same factors apply for analysis. Here's what we also know. We know that when the court changes someone's bail without good cause, that it is found to be an arbitrary and capricious decision. Now, we don't know where those two things meet, because frankly, Your Honor, we've never had that discussion before at this level. And I gave the state credit. I said, I didn't think they intentionally did this, Your Honor. I've been looking for this case law for years, but here they are again. It's ingrained in their argument. You shall not give bail. Wrong. They said it to you in writing, not once, but twice. They reiterated it in their oral arguments, just like they did here today. And that's why I said, Your Honor, wrong, wrong, wrong. And if they want something to hang on my motion for a reconsideration, that's all you need. That's it. That's the new fact. The state misrepresented the state of the law. Now, it might have been unintentional, but Your Honor, as of this moment, they haven't even conceded that it's a state of the law, and the law is staring at them in the face. The Supreme Court disagrees.
I think this, I mean, in reading this Bergman case, it seems to be all couched in the right to have bail on appeal.
No, Your Honor. They specifically call out section 178.44 in their analysis, and that's why I copied and pasted that. If you allow me, Your Honor. As a threshold matter, we first address the state's contention that under this state's statutory scheme, Nevada courts are, quote, without jurisdiction to grant bail as a matter of law once proof is evident and presumption is great that defendant has committed murder of the first degree. As this court stated in re Austin, there is little question that there is no constitutional right to bail following conviction and pending appeal. This is all in the same paragraph. They go from one to the other. The state argues that a defendant convicted of first-degree murder is not only without any constitutional entitlement to bail pending appeal, but is statutorily precluded from receiving bail under any circumstances. They extend the 178.484 subsection 4 argument to the appeal bond. And the court says the state's contention is primarily premised on its interpretation of NRS 178.484 subsection 4, which provides that prior to trial, a person charged with first-degree murder may be released on bail. The court cites to that section. It hasn't changed since this decision was offered in 2004. I looked it up. This has remained the exact same language as the language we're dealing with now, unless the proof is evident, the presumption is great by any competent court or magistrate authorized by law to do so in the exercise of discretion, giving due weight to the evidence and the nature and circumstances of the offense. More specifically, the state asserts that where a defendant has been tried and convicted by a jury of first-degree murder, the issue of whether proof is evident and the presumption is great has been affirmatively resolved by the jury beyond any reasonable doubt. Therefore, the state maintains enacting NRS 174.484 subsection 4, the legislature intended that the courts of this state are without jurisdiction to grant an application for release on bail pending appeal following the applicant's conviction of first-degree murder. We disagree on both counts. And the court goes through a lengthy analysis as to why it disagrees. But ultimately, the court says that the state's argument that 174.484 subsection 4 creates a greater presumption for denying bail than the appeal statute does for granting bail, an appellate bond, and that would create a disconnect. The Supreme Court says that's not true. These two can be read harmoniously if you simply don't buy the state's interpretation of 178.484 subsection 4. And the state Supreme Court, the Nevada Supreme Court, didn't. They clearly, black letter, resolved both of these issues in one fell swoop. And they said the state's position makes no logical sense. NRS 174.484 subsection 4 does not stand for the proposition that the court lacks jurisdiction to grant bail any more than when somebody is convicted of a first-degree murder charge, the court is robbed jurisdiction of granting bail. I told you, Your Honor, about the Edwards case. That is exactly what happened in the Edwards case, Your Honor. And while it's not analyzed in this black
case.
Huh?
You told me about a Crawford case.
I'm sorry, I call it Edward. I mistook that. I apologize. It's the Crawford case, Your Honor. The Crawford case is where someone pled guilty to first-degree murder, agreed they're going to be doing a life stint in court. And the Supreme Court still said it was error not to leave that person out pending sentencing. All of these read together. I mean, you don't have to go any further than Bergna, but the state hasn't addressed that. Even as they're standing here today, they won't tell you, you know what, Your Honor? Bergna is right. It stands for that proposition. Even as they're standing here today, and it's black letter. It doesn't get any more black letter than that, Your Honor.
All right, I'll take it under advisement and issue an order.
Thank you, Judge.
Thank you, Your Honor.